dedicated seminar would be interested, and indeed we believe that the response to our invitation indicates that we were right on that point. So that's me, Hans Bracquené. I'm a lawyer, which in the ESA is not a very common position, or in the ESA environment, but it helps for today at least. There are two practical issues that I was asked to stress. First of all, please keep your microphone mute. It helps to improve the connection. I hope the connection is all right. I didn't see any complaints yet, so let's keep it that way. And secondly, also, please rename yourself. It helps also when we have questions later, or also for any form of interaction. For example, and Rosario has put himself, give your name, surname, and the organization and country. That would be helpful to have that more or less standardized. This also allows me to thank Rosario, who is not a staff member of SME4SPACE, but who is the staff of SME4SPACE by himself. So he was again responsible for setting up all the practicalities behind this webinar. We start logically with an introduction. We will be discussing at a seminar like this, we will be discussing the principles. We will not go into the detail in a sense that we will not go and discuss alternative wording, alternative solutions for all the topics that are raised. It will be more at the level of principles. Although I will try to give you some, what I call tips and tricks, some practical solutions, yes, but also some pitfalls that from the years experience I've gained, but that's you gain them automatically by getting older, but that I've learned. So the structure of the talk itself, I will discuss, but very briefly, but I think it's important that you get also some legal principles of what intellectual property rights on itself are, because these legal principles, of course, influence directly the negotiations you might have with ESA, with the agency, but also within the consortium for your specific project. The contractual principles that will be leading us today, the specific contractual principles that will apply to the ESA contracts are, of course, the bulk of my contribution today. Where I have added, there's this part, or these are the tips and tricks, some of the lessons learned, and to be very educational, I've put these in red. Let me also stress, and that is something that I'm stressing not only when I'm giving a legal seminar, but that wherever SME4SPACE is invited to take the floor, SMEs can have both roles. So, and these will be addressed here today. We can be subcontractor, but we can also be prime. And I got a few questions in advance. I will try, let me also stress that I will try to address the questions that were sent in advance, but I will not be able to go into the detail of some of the questions asked, but it was indicative that these questions were not only from the point of view of a subcontractor, but also from an SME who is heading a consortium and who is not struggling, but who has to manage the issues related to the prime contractorship as well. For questions, I have opened, of course, the chat. I did not do so, but the chat is opened. I have an eye on the chat. When there is a specific question, or I address it, if possible, during my talk, and I will go immediately into dive immediately into it, or I will keep it for the question and answer sessions that is kept for the end, logically, and we foresee, let's say, between 20 minutes, maybe more, for the question and answer. So first, the contractual documents. The contractual documents, what are these? Well, the contractual documents, I think most of you will know them, but you will find them also in your ESA contract. These are the subcontract on itself. If you negotiate a subcontract, it is there. It is the subcontract and all the annexes that are attached to it. Important here are the minutes of the kickoff meeting, because some of the issues that need to be addressed, where decisions have to be taken, are sometimes only at the end, are only dealt with, are only decided upon at the kickoff meeting. So the kickoff meeting becomes at that moment an applicable document, becomes a binding document for the for the management of the consortium. The prime contract between ESA and the prime contractor, one could say that this is the basic contract, the basic contractual document, and part of that are the general clauses and conditions. And you will see that these ESA general clauses and conditions are for sure the leading document for us when we are dealing with intellectual property right issues and also with other legal issues, by the way. So the flow down of the general clauses and conditions from the prime contract to the subcontract is always a good starting point. When we had discussions on the standard subcontract, I said, let's keep it very brief here. We just say that the general clauses and conditions are flown down, and then taken from the perspective of a subcontractor, you certainly get a good level of protection for all topics, including intellectual property rights. But there might be a need to adapt these general clauses and conditions to specific needs. And these are, of course, then the tricky pieces. We should not forget that another applicable document is always the offer that you make. If an offer is made, you are bound by it. This is a legally binding document for the party that has been sending out the offer, as is the ITT or RFQ, as is the document coming from the agency or from your prime contractor, which both of them are also contractual documents. As you know, an order of precedence has to be agreed upon in your contract, but this is the starting point. There is now the ESA. Subcontract. There is a model subcontract that we have agreed upon. I mean that industry and ESA has agreed upon, and that is now, well, it's a standard, it's a model subcontract. Maybe you have heard about it, but one should say that for today, this will not be the major topic of our interests. Why is that? There are two main reasons. First of all, the clauses dealing with intellectual property rights in the model subcontract are limited. Let's say that the basic principles of the general clauses and conditions have not been dealt with during these negotiations. They have been accepted as being also the clauses and conditions that should apply to any subcontract. So in the model subcontract, there is only a very limited attention given to the intellectual property rights. Second reason why it is not that important here is that it is limited to, one could say, imposed, although this is not legally imposed, it should be imposed as part of the ITT documents, but it will only be used for the bigger programs. For the launcher programs, the PPPs, it's not yet, one could say, the standard program, the standard document. It's not the standard practice that it is attached, that it is part of the ITT. ESA can impose the use of the ESA subcontract model by the prime contractor, but then, as said, it should be part of the data package in the ITT. Even then, it is not really a template that can be used as such. It needs to be adjusted, and you will see, for those who have already been dealing with it, that there is a lot of gray. Gray meaning that these are elements that still need to be discussed, that still need to be adjusted to the specific program, and so that should be part of the negotiations you have within the consortium. For less complicated subcontracts, or for less complicated projects, the less complicated subcontract is certainly more adapted. And as said, the mere acceptance of the prime contract can be sufficient and probably would be advantageous for the subcontractor, as the general clauses and conditions on itself are a document that is well balanced and that takes into account the also the rights and obligations of the rights and obligations of the subcontractor. So the basis is are the general clauses and conditions of ESA. What is the relationship with the ESA subcontract? Let's say that, and we members of the legal profession, we like to use a few words in Latin every now and then, but that these are the general rules. That's the term general is well chosen here, and that the specific law, the lex specialis, is the subcontract. So one has to know that if you want a derogation from the general clauses and conditions, it has to be in the ESA subcontract, but in that case, the ESA subcontract will prevail in case of a deviation between the documents. Of course, that should be as such in the order of precedence in your contract, because you can derogate from that as well. In principle, you will have seen that Article 5 it's in the common practice of drafting the subcontracts. Normally, Article 5 contains the complements and amendments to the general clauses and conditions. Also, in the prime contract that is concluded, that is entered into by the agency and your prime contractor. It is, and let me go back here, one should keep that in mind, there is room for negotiation. It is not so that the intellectual property rights or all the rest of the general clauses and conditions, they are standard, yes, but these are not the law as such. There is room for negotiation. This is sometimes forgotten, and this is sometimes also used as an argument. I must say not so much by the agency itself. Of course, they will say they will stick to rules that are mandatory, but within a consortium, it is sometimes used as an argument. Look, it is in the general clauses and conditions, and we have to accept it. No, this is not true. And I'm starting here with the second point on this slide. One of the major risks, if you are negotiating as a second tier or third tier subcontractor, one of the major problems is what I've called the argument of the fait accompli, where you negotiate, if you have to negotiate with the prime or with a subcontractor of the prime, what you will hear every now and then, if not to say quite often, is, look, you have to accept it because it was already accepted by, and I'm just taking this as an example, because this was already negotiated between ESA and Airbus, and we have to live with it. This is, of course, what one should say, that within the consortium, this might be the major risk for negotiating, again, not only intellectual property rights, but on itself, during your negotiations as a subcontractor, this is the major risk that you could be confronted with. So negotiate, and that was one of the questions asked prior to this seminar, negotiate also during the tender phase. Make sure that if something is very critical to you, it is in your proposal, that it is clear from the start that this is your position on the topics that you want to see addressed. If we go to the general clauses and conditions itself, look at clause 10.4, which says that unless otherwise authorized by the agency, the conditions of the subcontracts shall secure the agency's rights as provided for under the contract. Obvious, one cannot negotiate a contract that goes against the rights of the agency. The conditions of the subcontracts shall furthermore reflect the rights and obligations of each subcontractor tailored to the subcontractor's area of responsibility. For subcontractors, this is, of course, the critical sentence of the general clauses and conditions that should be used whenever you negotiate and whenever the other party is not willing to flow down the conditions of the general clauses and conditions. part of the general clauses and conditions is that they should flow down these conditions, of course, only for your area, if you are the subcontractor, for your part of the job, for your job within the overall consortium. That goes without saying, maybe, but it's good. It's certainly a strong argument that it is explicitly in the general clauses and conditions. Before we dig more into the general clauses and conditions, a last, more general slide. These are, and as I've said it in my introduction, it would be very limited. It's only one sentence even. But what I think is very important whenever you are discussing intellectual property rights, there is one legal principle that you should keep in mind. And that is that it is never automatically the party paying that becomes the owner of the intellectual property rights. One always has to be very cautious when using terms like never or ever or absolutely. Well, there is one exception, and that is for database protection, but that is not the major topic of your major field of interest today. But it's not because, let's say, ESA is paying that it becomes automatically the owner of the intellectual property rights. It's not because a party is paying that it will become automatically the owner of intellectual property rights. So keep that in mind when negotiating the intellectual property rights within a consortium, or said that goes, of course, that is also valid for other environments than ESA contracts. So it is the inventor, the author, who is the initial owner of the IP. So he or she has to transfer it to the employer, has to transfer it to whoever, to a third party, to another party, to make sure that that other party owns the intellectual property rights. And if we want to have intellectual property rights transferred within a consortium or within negotiations, it has to be clear that these have to be transferred. It is not just by stating that a party is paying for it that that party will become the owner. So who will own the intellectual property rights? Well, not ESA. So it will be you being the party that has developed it, but you will have to give ESA, if you are a subcontractor, that will be done in principle through the prime. ESA will claim some rights to use the not intellectual property rights, but some rights to use licenses on the results obtained. So this will be dealt with later in some detail. The major definitions that one has to, which ones were on, yes, one has to be clear, is first the foreground, the results, because that will determine the deliverables, that will determine the rights of ESA and or the prime. This will determine on what of elements that these rights of use, for what elements these rights to use will be granted. All the rest, one could say, all the rest is background. And there the user rights will be much more limited. We will see later on that will be in the clause 43. But it is important that you clearly describe your background. If you do not do so, clause 43.1 will apply. And what does that say? It says that all intellectual property rights used during the execution of the contract are treated as arising from work performed under the contract, it's in red, unless and until the contractor provides the agency with evidence of the relevant background intellectual property rights. And you have to identify them, or they will be considered, they will be treated as, let's say, foreground, they will be treated as results. And so the rights of ESA on these elements will be much more important than on background that is clearly defined. I want to give that here as this at the start, because this is a major issue, but we will discuss it further on in some detail, what these rights on the background are. I said the ownership rights, the general principle, you have the references here. The principle is that the contractor owns all intellectual property rights. To be honest, this is not a bad deal. I suppose that some of you will have experience with other government-funded or contracts that are funded partially or not by public authorities. Well, to have it funded 100%, as is one could say the common practice of ESA, and still own the intellectual property rights, it's not a bad deal. There are some, although you are the owner, there are some obligations that you have. You have to inform the agency in case of an assignment of your rights. Not the most difficult one, but that will allow ESA, of course, to first to be aware of it, and secondly, to make sure that the rights that ESA have to be granted are protected. There is a duty to report to ESA in general on the results achieved. There is a duty to report on protectable results, but also on your intention to apply for protection or not, and on all the stages of your application procedure. If you apply for protection, patent protection will be most common here. You have to inform ESA about it. This is an obligation that you as the owner have towards ESA. It's a bit difficult to inform ESA of a negative decision not to apply, but okay, in principle, you should do so. And somewhere at ESA, there must be lots of reports on the results achieved, because there is, when you achieve results, you have to inform ESA of that. I think it's part also of the closure documents for your contracts. If you decide not to apply for protection, or in case you abandon your protection, there is indeed the duty to inform ESA, and a consultation procedure could start, which might result in a transfer to third parties. So ESA, if you decide not to apply for protection, or if you abandon your protection, ESA might request you to transfer your results, your foreground, to a third party. You might convince ESA that you had good reasons not to apply for protection. For example, if you want to keep it confidential and you know that during a patent procedure your application will become public, well, that might be a good reason not to apply for protection. And ESA at that moment may say, okay, we understand that, and we do not ask you to transfer these results to a third party. You don't have to do that transfer for free. It will be on favorable conditions. And if no third party is found, ESA can also request it to transfer it to you. Another obligation is to prove, and the legitimate commercial interest, you will see later, have some importance, but you will have to inform ESA every 3 years of the existence of your legitimate commercial interest. Otherwise, you will not be entitled to invoke them later on. And then the most important obligation you have as the owner of the results is that you have to grant access right to the agency, to participating states, and to persons and bodies. Well, I don't know who invented these terms, but okay, persons and bodies in meaning third parties, and to academic and research institutes. Here of course, we need to look to that obligation into some more details. You can find these also in clause 41. But before looking into what specific rights have to be granted, a major issue in negotiations is what do we have to grant to the prime contractor? This is a question that, one of the questions that was also asked to me, I think yesterday, by mail yesterday. How is that relationship here? When I am a subcontractor, do I have to grant rights to the prime contractor as well, or only to ESA? Well, here the standard subcontract gives a good solution. It says that the contractor agrees that the same rights are granted to the prime. The contractor here is the subcontractor. Sorry for that. Agrees that the same rights are granted to the prime contractor, however, limited to the extent necessary in order to monitor and verify the performance under the work under this contract, of the work under this contract. So, and it limits also the rest of that sentence. It limits the rights of the prime contractor to the use within a specific project. It is not the case that if you grant user rights to the prime, that the prime can use these freely. This is not automatically granted. The prime can maybe invoke one of the situations that I will discuss later on this slide, but you should keep in mind that, or you should deal with that issue that needs to really to be looked into in some detail. What rights are you willing to grant the prime on your results? You will need to grant user rights to ESA, and you will need to grant also some rights probably to the prime contractor. ESA, if you don't grant them to the prime contractor, but you grant them to ESA, that's fine with ESA. But of course, to negotiate so that the outcome is that the prime contractor does not get any results at all, no, that might be a bit overly optimistic to aim for that. So to be discussed carefully. What rights to use do you have to grant? And now I'm using, of course, the specific wording of the general clauses and conditions. The AG, you have to make them available to the agency, participating states, not all the member states automatically, only to those states that have subscribed to the specific program under which your project was funded, and persons and bodies, as said, other parties. You have there to give free user rights for the agency's own requirements, let's say for the other ESA projects. For use within other ESA projects, you have to give free user rights. There is no right to grant sublicense included in the rights to use that are granted here. You have to give it on favorable conditions, not for free, favorable conditions for a participating state's own public requirements to those participating states and persons and bodies. If you have results and these results are needed for a project with CNES, and France is a participating state in that program, you will have to grant user rights to use your results in that CNES program, not for free, under favorable conditions. A specific clause is dealing with academics and with research institutes. They get free rights for their own scientific research purposes, no right to grant sublicenses, and here the owner can invoke its legitimate commercial interests to avoid, one could say, or to escape from the obligation to grant user rights. These are specific rights. Then there is a more general one that says that you have to give access rights to each third party against market conditions, let's say normal commercial conditions, for use in space programs. For commercial space programs, public space programs outside ESA member states, and non-space applications. So you have to, this is basically a good faith, an obligation to act in good faith. If somebody comes to you and that party wants to use your results, you should negotiate in good faith with that party for the grant of these user rights. You don't have to give it for free. You also have to negotiate the market conditions, unless, again, you can invoke your legitimate commercial interests. So these are the main obligation. This is the main obligation, the obligation to grant these user rights. This is what you have to give in return for the intellectual property rights that are granted to you under the general clauses and conditions for ESA contracts. Specifically for software, there are some additional obligations. You have to assist ESA, because we are talking here of the ESA general clauses and conditions. You have to, a contractor with ESA has to assist ESA with installation and training. You have to deliver the object code. Lengthy discussions sometimes about the source code. Well, to ESA, in the ESA general clauses and conditions, it is said that you have only to give source code for ESA's own requirements. So you have to give the source code, but ESA cannot grant access to the source code to third parties. It's only for ESA and for ESA's own requirements. The escrow, I think that you will be familiar, certainly for those who are attending and are with a software background. The escrow is included, if included, in the ESA subcontract, there might be an obligation to make a deposit with an escrow agent. Updates. This is a critical issue for ESA. I know from negotiations I have had with them. Of course, they want to have updates. If you deliver software and the software is no longer updated after a few years, or maybe very quickly, the software can become out of date. So there is a general clause saying that updates shall be provided to ESA, but only for ESA's own requirements, again, and against favorable conditions, not for free. There is a specific type of software, the so-called operational software. Operational software, well, it's software that is critical to the operation of satellites or the operation of, let's say, other deliverables. At that moment, the whole thing can be turned around. ESA can request, there is no automatism here, ESA can request the assignment of all IPR to ESA. There will at that moment be a grant back of a license to the contractor, but the use for which this license is granted will have to be defined in the contract, and there will be no right to sublicense. So you see, quite complicated maybe, but this is a model that within negotiations for software development, we find every now and then, and we will see later on that it's also used by the EU for its space programs. Of course, software provisions can be adjusted and supplemented in the ESA subcontract. As said, this goes, this is a general statement, one could say, as long as ESA's rights are safeguarded. Background. We already have seen that background is critical, and I've seen also that Xavier Verians made a comment in the chat saying that documenting background is not always easy. It most certainly is not, but it is unavoidable. So it's, as said, the main risk is that if it is, one could say, incorporated in other deliverables, it will be considered foreground, and that all these user rights that we have just seen have to be grounded on your background. So caution is required here. For the background, the main principle is that each party shall remain owner of its background, and that indeed a list has to be added. You can, under the general clauses and conditions, you can add background during the contract and even thereafter if you can evidence it. And it's important here to say that in the ESA standard subcontract, it is different. There, the change procedure, which implies the approval of all the parties involved, has to be followed. So there is less freedom to add to add background under the standard subcontract than there is under the general clauses and conditions of ESA. This is a limitation that has been introduced there. So be cautious if you are working under that subcontract. But what rights have to be granted under these background rights? Well, this is probably the most difficult part of the general clauses and conditions, or on the IPR clauses. First, for background developed under other ESA contracts, it's clear. If there is background used that was developed under another ESA contract, the rules of that ESA contract will apply. So in principle, if it is reused in an ESA contract, of course, these rights to use that we have just seen will apply. And if it is used by ESA or by a participating state for another ESA project, in principle, free user rights should be granted. A license has to be granted for the use by ESA of the results achieved under the specific project. ESA does not want itself to be blocked by background rights. This is, one could say, a general principle of law, of course. You cannot invoke the rights you have just to block the other party. You cannot come after the closure of the contract. I have some interesting background here, and now you have to pay some extra before you can use it. This is, as said, a principle of good faith, but it's useful certainly to have it here. And background will have to be licensed to ESA for the use of the results that were achieved. What for background of a third party that is used? There you have to use reasonable endeavors to ensure that a third party grants the license for the execution of the project and the exploitation of the results achieved. Reasonable endeavors have to be used. This is not a strict warranty that has to be given. So if third-party background has to be used or is used by your partners in the consortium, have a look at it. Make sure that these reasonable endeavors does not mean that you are blocked later on in the execution of the project or in the exploitation of the results. If another party is requesting access to your background for another ESA project, not the one under which you are using that background, you have to give a license, but you will see it is against market conditions. And again, you can invoke your legitimate commercial interests. If a competitor of yours is asking for use of your background in another project, it's clear that you can invoke then your legitimate commercial interests, and you do not have to give that competitor access or to your background, or at least not user rights on your background. Source code has to be made available to ESA, not to the prime or other consortium member. Be aware of that. Subcontractors, strangely enough, subcontractors should be granted license on favorable conditions for the execution of the project. So if you are working with subcontractors, you can ask for a compensation for the use of your background. I think this is a bit strange, but this should be looked into, and all these background issues, I think these need to be negotiated when tendering. During the tendering phase, it has to be clear who will be using what background and under what conditions that background will be brought into the consortium. And it was already said, yes, but in the questions here, yes, but what if other background becomes necessary? Yes, indeed, you cannot foresee everything here, but normally the bulk of your background will be known at the start of the or even prior to the start of the project, and should be put on the table, so to say, and negotiations should lead to a clear position on what can be done, so on a clear, outcome of what can be done with that background. I just put, it's the only one clause I've put here, just this is the one, if ever there is a new, for those of ESA attending, whenever we are going to work on a new version of the general clauses and conditions, this could be rewritten somewhat to make it more accessible. I think that the terms here are not so strict as they are in other clauses. So maybe from SME4SPACE we will make a proposal in that sense. Not to change the principles, these are fine, but to have it a bit differently written. Okay, these are the clauses dealing with, one could say, the execution of the contract. What after the execution of the contract? I said, you are the owner. There are few obligations still after the execution of the contract, mainly the one on the grant of these user rights, and also probably, not probably, also the reporting rights that we have discussed a few slides ago. Is there an obligation to exploit your intellectual property, your results? No. You have to report on the exploitation. Again, somewhere at ESA, all these reports must be kept. But there you have to use reasonable endeavors to exploit. There is no strict warranty on it. There used to be a time, well, it must be, I don't know, but more than 10 years ago probably, but there used to be a time when in the general clauses and conditions it was foreseen that ESA got royalties based on the use that was made by the results outside the ESA contracts. This is no longer the case. Unless it is foreseen on the contract, it used to be the other way around. So you needed a waiver in your contract, a waiver from ESA for its right on royalties for these uses. You have to give, sorry for the typo here, you have to give reasonable assistance to each other in case of an infringement. I think it's a standard clause that you will find in lots of development contracts. You have to give support to each other in case of an infringement of your rights, or if ESA is attacked for using your rights. A very specific one, and to be honest, I'm not so sure whether it is invoked that often. It is invoked, I think, or it's used without referring to that clause 47, but it would be interesting to know from you whether you have used it before. Is the clause 47 the right to resupply? ESA has a right of first refusal for any resupply of products at fair and reasonable price, but one could say that you have a right of first refusal to resupply as well. At that moment, if ESA is, planning to procure exactly the same as the one that you have already delivered, at that moment, this clause can come into play. At that moment, there will be no competition procedure, and the tender will only be the tender procedure will only be started if no agreement can be reached between you, the one who made the delivery the first time or the second time, if there is a third time, if no agreement can be reached, and the priority for the during the tender procedure, there will be a priority for the original contractor if the conditions are equal. So there is the right to resupply or the right of resupply. Well, as it is here, it looks like something quite important, but as said, I haven't seen it used that often. Sorry. It's also, by the way, it's also not only for the ESA own requirements, but also for the participating states' own public requirements. So again, if not to use CNES again, if DLR does it and the DLR is participating in the program, there the clause 47 should applies as well. Then there is the transfer outside member states. This is not that long ago that the obligation to pass through ESA, I don't remember the name even, but a board where each member state had a look into it prior to exporting your results outside of the ESA member states, it does no longer apply. So that board has been abolished, and the only obligation is there, which is, well, it is an obvious obligation, one could say, is that you have to apply the applicable legislation for transfer outside member state, the export legislation, which on itself is, well, one or two seminars on the export regulations could be useful as well, but there is no longer a specific clause or imposing a specific procedure before you can, from ESA side, before you can transfer your results, your IP, outside the member states. There was already a clause, I thought, on, oh no, it's another question. It's another question related to 100% funded ESA projects, but I will come to that later. Because for co-funded contracts, the ones, for example, under RTS, the ones under GSTP, you have a special regime. A special regime where, let's say that the user rights that you have to grant are more restricted. This is not the most important, but basically the only difference between the fully funded and the co-funded contracts from the perspective of intellectual property rights. This is the major difference. It says that you only have to give free licenses to ESA, not to the bodies and persons, not to the other participating states, for ESA's own requirements. Participating state, persons and bodies for ESA's own requirements against financial conditions. Another term, what are financial conditions? Financial conditions are market conditions, but reflecting the work of each partner, also, let's say, the funding of each partner. So let's say that if you have to negotiate with a party on the financial conditions, what arguments can you use? Well, you can use that logically. I've had to pay 50% myself, so you will get, well, market conditions less the maybe depreciation of the 50% I had to pay myself, something along these lines, of course. But this is the definition. This is what financial conditions mean. But here also limited to ESA's own requirements and to participating states and persons and bodies. So the rights you have to grant on results obtained under partially funded contracts are always limited to ESA's own requirements, and the financial conditions, or the financial conditions will be financial conditions, sorry, but the financial conditions will be those that are given here, but only for free to ESA. As soon as it's another party comes into play, you no longer have to give any free license. For all the rest, for all other purposes, you can ask for market conditions. So it is not that different, one could say. If you look, all these clauses are very similar, but of course the rights you have to grant are much more restricted than the ones you have to grant under the same ESA general clauses and conditions, but applicable to fully funded contracts. What about EU contracts? I want to stress that we are not talking here about Horizon 2020 or Horizon Europe contracts. We are talking here about the contracts for Galileo, Copernicus, so the contracts with ESA as an agency. Well, ESA, you will have a contract with ESA maybe, but it will not be under the ESA general clauses and conditions that we have discussed up until now. There it will be completely different. There the IPR will go to the EU, maybe also ESA, but let's say to the EU and its institutions. So you are not the owner. Forget everything that I've said up until now. If you were here attending that seminar and hoping to get some answers on questions you have related to your participation in these programs, the EU funded projects, forget everything. All the IPR will go to the EU and its institutions. There is foreseen that there can be a grant back of licenses, but I can assure you from my personal experience, it is possible, but it's not always easy to get it. It's not always easy to get a commercial license allowing you a commercial use of your intellectual property rights achieved under Galileo, because you have to negotiate it with the Commission, with the people at the EU, and well, not only it is, and people of ESA will be happy to hear that, not only it goes much slower than it goes to, and that is very slow than it normally goes with your negotiations at ESA, but let's say to have a position that deviates from the overall line that is, we don't like commercial use outside of our programs, it's not always easy to obtain such a license. For PRS, the public regulation services, but those who are working within the PRS projects are certainly aware of that. This is done on the PRS being, well, publicly regulated, like more the security part of Galileo. There, of course, this can only be done under very strict conditions. It is on the specific programs, it will also be not possible to transfer the decision center of your company outside the EU or the member states, and if you want to keep the rights that are granted to you. And again, that might come as a surprise to some of the SMEs in that case, who were thinking about a takeover or an IPO or financial transactions like these. What will be with the Brexit here? As we know that this is, of course, a very interesting case from an international law perspective, where we'll have well, the UK participating within remaining a full member, of course, of ESA, but not of the EU, we all know. And for those participating in the projects and participating in the latest tender procedures, we know that this has become a very tricky situation. This is more or less my talk for today. So, some points of attention. Start from the flow down of the IP ownership, and you are starting as a subcontractor, you are certainly not in bad shape. The IP rules of the general clauses and conditions are not bad for industry. And there was a question here asked by Nick Berry of Plasmabound. How does the scenario of 100% funded project reflect on the de minimis aid rules within the EU? Well, this has not so much to do with the de minimis aid rules, but everything to do with state aid rules, of course. Let's say that a national state can certainly not give you that. A national state can certainly not give you 100% funding and the intellectual property rights for the funded the company that receives the funding. That is infringing the state aid rules for sure. But luckily, one could say ESA, the state aid rules do not apply to ESA. ESA as an international institution, and there has been lots of discussion about it, but ESA as an international institution does not fall under or within the field of application of the state aid rules. Another major topic, the user rights for ESA. Are these also, will these also apply for the prime? Will the prime be entitled to invoke them? Or will the prime just be, one could say, the mailbox through which the intellectual property rights pass, and that where only, but the use that they can make of them is very limited. This is a major topic for negotiations during your contract negotiations within your ESA consortium. I think I have underlined sufficiently, I hope I did, the importance of your background list and the change procedure. A difficult one, I know, a difficult one, not so much or not only from a legal perspective, but certainly also from a technical perspective, how to describe your background. Give ESA the user rights it needs, but not more. As said, there is room for negotiation also on these user rights. ESA, is my experience, wants to have the comfort that it will never be blocked in the user rights it gets, in the results it gets. If you can assure ESA that they will have that warranty, the warranty that they will always be able to use the results for which they have paid, and maybe they do not need all the user rights on your background or not even on the foreground that are granted, I think at that moment there is some room for negotiations. Be careful with the source code, whatever there is source code, but this is probably the open door of today. Be careful when I say that you have to be careful with source code, but this is true in consortia with ESA. It is good that some attention is devoted to it. Who really will receive the source code? Be careful on that and be detailed on that in your contract. There is room for negotiation, as said several times. I'm repeating myself. And finally, do not forget to have a look into these issues in the tender phase. It will be, or it can be too late later on. If you only start negotiating on the intellectual property rights, on the conditions that will apply to the user rights granted, and so on, it will be too late. Not only for the risk, as I said, of the fait accompli, where you all of a sudden are against the wall. That is, and sorry for using the same example, but that ESA and Airbus have negotiated a contract and there you are with your rights as a subcontractor. No, but also within smaller consortia, because it's then that you still have the possibility, or sufficient degrees of freedom to negotiate. That's more or less it. I will go to the questions. Of course, I have to do that with the chat, meaning that I cannot give you the floor. I can start by saying, but Rosario already did it, Rosario in the chat. The slides will be shared later on. I've dealt with the one on the state aid rules. Last slide said that rights may be claimed by ESA, does not claim them. What is the formal requirement? They range from parents resulted to pro. When can ESA claim? Oh, it's shifting here. When can ESA claim these rights that I was referring to? I think in one of the first slides. This is a very limited, and to be honest, I've never myself. I'm not aware of ESA claiming intellectual property. I'm sorry, Luca, you want to intervene? I saw somebody asking or trying to intervene. No, I thought maybe it was the person who said these questions. So what is the formal requirement? The formal requirement is if you abandon the formal one is really related to IP protection. Formally, for the rest, it's related to the lack of effort, I would call it, to use the results obtained. This is not so uncommon in contracts with funding authorities, but it's very uncommon that these are really invoked. And I said, I'm not really aware of it. That does not mean at all that it did not happen before, but I'm not really aware of ESA invoking that right. Background source code to ESA. Are we sure about commercial products here? Peter Baumann is asking that the background source code has to go to ESA. Well, ESA has to get rights to the background source code, but only to use the results obtained. It's not for any other use. So indeed, the source code, again, it's all part of that position, that overall position of ESA, and especially the people who are dealing with software have, how would I say, have that uneasiness with source code, with what will happen to us if we do not get sufficient rights. They are the ones, if there is from within ESA, from within the agency, some pressure to change the general clauses and conditions and to turn that around. It comes basically from the people dealing with software or with integrated circuits, with ICs, who always are, there is the fear that at one moment they will be blocked by some black boxes. So again, the principle here is, yes, we do need only ESA do need access to the source code, but that access is really limited to ourselves. Somebody is saying that he is enjoying it. Thank you very much. Am I correct that with the standard contracts, no single clause regulates something between different subcontractors? There is a legal link to the prime, but not between different subcontractors. Is that correct? Yes, it is. Yes, it is. So one could make a consortium agreement, as is done, for example, under the Horizon 2020 and Horizon Europe contracts. But on itself, indeed, it's only that's the relative value of a contract. The contract only binds the parties to the contract, being ESA and the prime and the subcontractor that is a specific subcontractor here. You can make it different, and you can, in one contract, you can have more subcontractors becoming a party to it, and then and arrange in that subcontract also if a transfer has to take place between different subcontractors. I mean, transfer access rights have to be granted, and as I've been stressing that you should look into some detail. Well, it might be advisable to have all the subcontractors or those working, for example, under the same work package into a specific subcontract, or to make it into a real overall consortium agreement. General differences between ESA Contract Expo Plus and standard ESA contracts. Sophie Jutten, I thought, Sophie, that Expo Plus, the general clauses and conditions do apply. That Expo Plus is, but I think that the general clauses and conditions do apply. So the Expo Plus procedure is much shorter, at least that's the aim. And I think the contract on itself might be shorter. And again, this is the aim, but I believe that the general clauses and conditions apply, so that the rest of what I've been telling you applies as well to a contract under Expo Plus. I believe what you spoke today covers both RFP and ITT, for example. No, yes, well, it's the same question here, Nick Barry, that, okay, no, Claudia Ambris, which I well know, says that they do not apply. I'm sorry, I should check it. Expo contracts are self-contained, so they do not apply. I should check it, sorry. Peter Baumann, can open source software be mandated by ESA as it wasn't? Well, can it be? Yes, I don't see any reason why it cannot be. So can open source software be mandated by ESA as it was in several ITTs now? Yes, I don't see any reason, certainly not from the perspective of contracts taken from the point of view that we have been dealing with today. That depends what is in the ITT. Well, that's others decide on that, and other rules apply there. It might well be IPC that is going to decide on what is in it. So can an open source proposal be put at an advantage in evaluation? Again, that will depend not on that will be reflected later on, for sure, in the contractual clauses, but that is not on itself part of the contractual conditions as they are now generally known. Yeah. I think these are the questions that I've been dealt with. I book a semester also on Expro Plus that they ask for free background license, indeed. The use for the background licenses, I don't know whether that is then limited as it is under the general clauses and conditions. I don't know, but these, I don't think there are for the moment any other questions. No. Then I go to what I would call the classic there is one here. What does own requirements mean? This sounds a bit vague and potentially subject to ESA own interpretation. Well, I should not think so. You can, let's say that ESA own requirements are the ESA projects, the ESA programs. So it's that's it. So I don't think that this has led, but again, I don't know whether others have other experience there, but from my point of view, this has seldom led to any discussion. I don't know who shifted the slides at the moment, but somebody, probably Rosario, otherwise I would have done it myself, because this is our footprint now, and we want to end with that. The footprint of SME4SPACE is growing. This is a positive one. Positive footprint, I mean. This is improving the environment. You will see each time I show it that we have new members, and we continue to have new members at a regular basis. If there are people here attending from Scandinavia, I always say the same. Scandinavia is really for us the from Sweden and Finland. There we would like to see some individual members, companies who can act as the liaison for their delegation, for their colleagues within SMEs, as Bracquené is doing in Norway. But if there are associations that would be interested in joining us, please feel free to contact ourselves, Rosario or myself, and join SME4SPACE. Thank you very much.
Hans, I believe there is another question. I don't know if you check the chat.
If you want to. Yeah, but it's also an Expro Plus. I said I did not look into this. What would the impact?
Yeah, maybe I can just amend here that the waivers to the GCC in the Expro Plus can be found in the Annex 1 of the contract documentation. So it's not much, and you can check for that in the Expro section on EMITS. If you have a look there in the tender conditions, I think you will find the Annex 1 with the it's just one page on the waivers of the general clauses and conditions.
Yeah, thank you, Jens. But it's clear from the number of questions, there were a few. I think for the next version of this seminar, I promise to all of you, I will incorporate the Expro Plus clauses as they will be applicable at that moment. But you can find them already where Jens just told you. Any other questions? No, the advantage of working with a chat is that you don't have to wait for the first question, huh? As you normally have to do after. There is no big issue in somebody being.
Yeah,
nobody wanting.
Hans, Rosario, we can somehow trace the questions and then check afterwards if we missed any of them accidentally.
Okay. Well, and as said, you can still send them to us as well, or to Jens. I know that Jens is also receiving IPR related questions every now and then. Thank you. I see a lot of thank you coming in our directions. So let me thank you. Thank you everybody for being with us, and again to you, Jens, for supporting this seminar, Rosario for setting it up, and talk to all of you probably soon, and to some of you for sure we will talk soon. Thank you.
Okay, thank you very much, everybody. Bye-bye.